We're live.
Good afternoon. It's the 15th of March, 2022. This is a hearing of the House Judiciary Committee. We have three bills that we're hearing today. The first is one that I introduced on behalf of Baltimore City and Mako with regard to concurrent civil jurisdiction of ordinances. I'm not going to talk a great deal about it. I'm just going to hand it right over to the panel. DePaul Nibber from Mako, Laura Price from the Talbot County Council, and Adam Levine from the Baltimore City Solicitor's Office. I'm just going to pass it directly to them. They'll each get 2 minutes to testify, and then we'll take questions. So Mr. Nibber, if you're there. Mr. Nibber, we'll go ahead and we'll hear from you first for 2 minutes on the bill. Like I indicated to the committee, I didn't go into details about it. I did this as a courtesy for Mako because of a recent Court of Appeals ruling. So that's the bill actually came in late for that reason. So I'll let you talk about the bill. Mr. Nibber, please go ahead.
Thank you so much, Mr. Chair and Mr. Vice Chair and members of the committee. My name is DePaul Nibber, representing the Maryland Association of Counties in strong support of House Bill 1448. And thank you again, Mr. Chair, for sponsoring this bill. The Angel Enterprises case, which unfortunately I didn't have a chance to tune into the beginning of this hearing, but I don't know how much has been addressed here, but the case essentially...
Nothing. So go ahead and we'll
get
a little bit of time. Okay, go ahead.
Yep. So the Angel Enterprises case essentially highlighted a portion of our state code that essentially says that any sort of administrative review of a civil matter based on local law has to go before a state district court. This is problematic because many counties have an administrative review process for very small civil matters, simply because it's a more informal and less costly way to appeal a fine or action levied against a constituent than by going to district court. So this extends to everything from traffic citations to nuisance violations, and it applies to multiple jurisdictions across the state who employ administrative review processes for civil matters arising out of local law. So to be clear, this bill is not intended to usurp authority from our state courts, but rather preserve existing county administrative processes. All review done at the county administrative level may be appealed to state court. Absent this bill's passage, as outlined in our written testimony, we fear that jurisdictions currently employing administrative review processes may be subject to lawsuits regarding unlawful enforcement activity, extensive rewrites of existing ordinances, and a flood of novel cases in local district courts at a time when courts are already backlogged. And for these reasons, we urge your support for House Bill 1448 and request a favorable report. Thank you.
Yeah, fighting with Zoom. If we could now go to Laura Price, please, for 2 minutes.
Thank you, Chair Clippinger and members of the committee. I appreciate the opportunity to come before you. My name is Laura Price, and I'm president of the Maryland Association of Counties and member of the Talbot County Council, testifying in strong support. To better understand the issue, I think it's best just to share the story. In 2006, the owner of an unimproved property in Talbot County began clearing trees to build a driveway, despite being told by the county that he couldn't do so. MDE discovered the violation and alerted the county. In 2009, we issued abatement orders to the owner for cutting trees both inside and outside the critical area in violation of the Forest Conservation in Critical Areas laws. The county also directed the owner to remove the driveway and restore the property. The abatement order stated that the owner would be liable for civil penalties of up to $1,000 a day per violation until they were abated. The violations were not fully abated until 2015, at which point the fines totaled over $700,000. The owner appealed the fines to the county's Board of Appeals under Chapter 58 of our code. After multiple hearings in 2017, the Board of Appeals held that the county had the authority to impose the fines, but disagreed on the amount. On judicial review in 2019, the circuit court determined that the owner was liable for the full amount of the fines. In 2020 on appeal, the Court of Special Appeals agreed that the owner was liable. However, it ordered the case sent back to the Board of Appeals for further analysis. And last year in 2021, the Court of Appeals held that the assessment notices issued by the county were invalid and unenforceable because they only provide a right of appeal to the Board of Appeals. So under state law, only the courts have the authority to decide such matters. And they further held that any sections of the county code granting a right of appeal in conflict with the state law were also invalid and unenforceable. After 15 years of litigation and nearly $200,000 in attorney's fees and court costs, the county was unable to impose a fine for particularly egregious violations of the county's critical areas and forest conservation laws. We got nothing. Members of this committee, it's important that this body fix the issue so counties can oversee our own zoning codes and impose fines that are enforceable. And for those reasons, Talbot County is asking that you find HB 1448 favorable. And thank you. I can answer any questions you may have about the case.
We also have Adam Levine or Levine, please, for 2 minutes.
Good afternoon, Chair Clippinger, Vice Chair Moon, and members of the committee. Thank you for your time. My name is Adam Levine. I am an attorney with the Baltimore City Law Department, which represents the city of Baltimore. My experience with this proposed legislation relates to my background advising the city's Department of Transportation with regard to the hundreds of fines that the department issues each year relating to violations of regulations of contractors using the city's public right-of-way for various projects. But the city also has various other agencies that issue fines that arise from the violation of local law. For instance, housing and building code fines, zoning fines, sanitary sewer fines, late night commercial license fines, and many other ways in which the city has created a system of administrative review with agency hearings to review complaints made by those who have received these fines. Review, the contractor or whoever has received the fine always has a right to judicial review. They always have a right to go to court. The difference is that because of the opinion recently issued that Mr. Nibber spoke about, now rather than being able to have an administrative hearing first with a right to go to court after that's done, the fine will have to be adjudicated from the very start in the District Court of Maryland. And I can say from my experience that in all the years representing the Department of Transportation, I have attended many hearings relating to many fines. None of these have ever gone to circuit court for judicial review. The contractor always has a right to do that, but they never have. So the system has been successful in resolving these things short of going to court. And we would like to preserve that for all of our agencies that handle these kinds of fines. I just want to emphasize, yes.
I need you to wrap up, please.
Okay. The one last point that I want to make is that no local government has to have a system of administrative review. It's only optional. That's why it's concurrent jurisdiction in the bill. Thank you very much. And if you have any questions, I'd be happy to answer them.
All right. Are there any questions for this panel at all? Any questions for the panel? All right. Seeing none, we thank you all very much. And that concludes the testimony on House Bill 1448. Thank you very much.
Thank you.
Thank you. We're going to go now to, I don't see Chair Atterbury on here, so I'm assuming that I should go to not chair, but to Delegate Anderson.
Yeah, thank you, Mr. Chairman.
All right, so we'll do that. We're going to go to you, and it's House Bill 1442, 3 minutes for Delegate Anderson, 2 minutes for everybody else. The words "me" and "to" are always welcome. We'll hear first from Delegate Anderson, of course, who will not say "me too" because he has to tell us what the bill does. Megan Murphy, Mary Denise Davis, Christopher Sweeney, Harold Coldman. Let's just do that. We'll hear the people on the first page and then we'll go from there. Okay. So Delegate Anderson, fire away. 3 minutes.
Yeah, thanks a lot, Mr. Chairman, and good afternoon, everybody. This is an expungement bill. And as many of you already know, expungements are allowed under current Maryland law, immediate expungements for cases when a person is accused of a crime, and then the result of the disposition in the case is either a null pros, a not guilty finding, a dismissal, and for those cases, you can automatically have your record expunged. Now, one of the things that I found curious about the law, and part of what this bill does to change, is that if you get charged with a crime and you go to court and you get found not guilty, or if you go to court and the state's attorney decides to drop the charge, or if you go to court and it's a dismissal by the judge, you still have to wait 3 years before you can get your record expunged. Or you can sign a waiver and get your record expunged immediately. But the waiver says, I agree not to sue anybody as a result of my arrest. And that never made sense to me. If you get arrested and it's a wrongful arrest, and you feel as if you have a cause of action against that police agency or the person who accused you of a crime, you shouldn't have to wait 3 years to get your record expunged if you still want to file suit in that case. So this bill changes that in cases of dismissals, excuse me, in case of dismissals, not guilty findings or acquittals, and null process by the state's attorney's office, that you can get immediate expungement of your case. You don't even have to file. The court's got to do it immediately. And it is, you don't have to sign any kind of waiver. The other thing this bill does, though, is also changes the waiting periods that currently exist in Maryland law with regard to expungements of felonies and misdemeanors. And I think all of you are aware of the fact that in the last couple of years, we said you can get certain misdemeanors expunged, but you got to wait 10 years. You have to wait 10 years to get a misdemeanor expunged from your record. Yeah, you did something wrong, but it was a misdemeanor, and you've served your period of time. If a judge gave you time, or if he gave you probation, all of that's over. But you still have to wait until after the probationary period is over for 10 years before you can even file for an expungement. So a person that has this happen to them at 21, 22 years old, it's got to wait till they're 30, 32 years old. This bill would change the waiting period for misdemeanors from 10 to 3 years, and for the misdemeanors and felonies that we require there to be a 15-year waiting period, this would reduce it from 15 years to 5 years. Now, this bill is a cross-file with Obie Patterson's bill in the Senate. I had a hearing last week, and the state's attorney's office came up with several problems that they had with the bill. And we talked to Mr. Cox over that interim, and we are making changes to the bill to reflect every single problem that the state's attorneys had with this bill. So there'll be significant parts of the bill that will be taken out as a result of that conversation. Mr. Cox can tell you what those were. I talked to him this morning, and the person from the JOTF, Christopher Dews, also was part of those conversations. He's one of the people that will testify today. Finally, the only other thing I wanted to point out is that in the law, in the expungement law, you can have your acquittal expunged, but there's nothing, the law doesn't mention anything about having a not guilty verdict expunged. And I talked to Claire about that, and she thought that, well, since we're cleaning up some of these expungement laws, we should probably put the words not guilty finding or finding of not guilty in the law to reflect what happens when a judge finds you not guilty in a district court action.
Delegate Anderson, I'll need you to wrap up.
I'm wrapped. Thank you so much, everybody. And obviously I'll be free to answer any questions.
That's fine. Let's hear now with Mary Denise Davis, We don't see Megan Murphy in the waiting room. We don't see Chris Sweeney in the waiting room right now. So we'll hear from Mary Denise Davis from OPD, and then we'll probably pick up some more people if we can't find the people who have already called. So Mary
Hello.
Denise Davis.
Good afternoon. I do know that those individuals are in the waiting room. They texted, they just hadn't been left in yet.
That's fine.
So
We'll
sure
hear from
they
you
will.
we'll hear from you for 2 minutes. Go ahead.
Okay, thank you. Mary Denise Davis with the Office of the Public Defender. The Public Defender is here today in support of House Bill 1442. I will say I've been intricately involved with the PD's work around expungement, providing weekly clinics, an annual event, encouraging line attorneys to file expungement for their clients in criminal cases. And myself and other staff members, we have clearly seen the benefit of the expanding expungement eligibility that this legislators have passed over the several years, starting in 2007. Greater access to employment, housing, education, everything that the advocates talk about, the benefit of expungement. And I would encourage all of you to keep going in that direction and keep saying yes to making the expungement statute even better. And as Delegate Anderson said, some of the things in this bill are kind of cleanup, little things that those of us that do expungement work for the clients don't make sense. Like, why is it not guilty involved? Why isn't an invalidated, dismissed fugitive warrant involved? Why can't you file for expungement as soon as you're finished your probation before judgment? But one of the things that I find that will have the greatest impact of this bill is how it expands the number of misdemeanors that will be eligible. It basically flips the switch. So instead of like cherry picking this conviction, that conviction, it says these misdemeanors are eligible. And then there's, of course, the list of those misdemeanors that are not going to be eligible. I'm sure the ones that the state's attorney would object to if they were there. Anything about animal cruelty, domestic violence, DUIs. So it's so much easier when you're talking to a client to say to them, misdemeanors are eligible, but these are not, because it makes sense why some misdemeanors may not be eligible. So I think I'm getting close to my 2 minutes, but I wanted to thank you all. I hopefully we'll have a favorable report, and I will be available for any questions.
Howard Coleman, please, for 2 minutes.
Did you ask me?
Howard Coleman, please, for 2 minutes. Mr. Coleman? Mr. Coleman?
Delegate Clippinger, did you hear my testimony? Mary Denise Davis? Okay,
Yes,
just making sure. Thank you, I appreciate it.
All right, don't go anywhere. There might be questions. Howard Coleman. All right, well, let's keep trying to go down the list and we'll see what we can do. Nicole Hanson Mundell, Caleb Yasso, Kiana Johnson, Norman Richardson. Nicole Hanson Mundell, please. We only have Caleb, so we're going to ask for Caleb Jasso, please. All right, 2 minutes, please.
Thank you, Mr. Chairman, members of the committee. My name is Caleb Jasso. I'm a policy advocate with the Job Opportunities Task Force, an independent nonprofit organization that develops and advocates policies and programs to increase the skills, job opportunities, and incomes of low-skilled, low-wage workers and job seekers in Maryland. I'm also joined here today with our senior policy advocate, Christopher Dews, who has worked very closely in the rewriting of this bill, as it was mentioned earlier. I'm here today just to kind of briefly touch on what other states are currently doing and what their rules are for expungement policies, just to sort of support what we are trying to get accomplished here in Maryland. So Currently, the waiting periods for misdemeanor convictions range from a high of 10 to 15 years in Maryland, depending on the nature of the offense, to 0 years in Mississippi, although only first-time offenses are eligible, with most states falling at the lower end of that range. Of the 44 states that authorize clearing of misdemeanor convictions, a near majority have a waiting period of 3 years or less, 19 states in total. And the vast majority have waiting periods of 5 years or less, about 35 states. The waiting periods for felony convictions range from as high as 10 or 20 years in North Carolina to as low as 0 to 2 years in California, with most states falling at the lower end of that range. Of the 35 states that authorize clearing of felony convictions, a near majority have waiting periods of 7 years or less, being 17 states. Additionally, Oregon has reduced their toughest misdemeanors down to 3 years from the date of conviction. Texas currently has a waiting period also of 0 to 2 years for a misdemeanor after completion of the community supervision or completion of the person's sentence. I will wrap up by just saying that we are here today in strong support of this bill. You will hear a lot of personal, strong testimony from many of the panelists here today, as well as significantly more information from our senior policy analyst, Christopher Dews, who I will refer to for any further questions. We urge a favorable vote, and I thank you very much for your time.
Thank you very much. We'll go now to Chris Sweeney for 2 minutes, please.
Thank you very much, Chair Clippinger, and thank you to the members of the committee for allowing me to testify today. I'm Chris Sweeney with Maryland Volunteer Lawyer Service. I'm here to strongly support this bill, including the sponsor amendments that Delegate Anderson mentioned. I work with our Workforce Development Project, which means I assist job trainees in reducing barriers to employment. I am a staff attorney and I have helped over 700 people in filing for expungement of records. So this is an issue that is very personal to me. I just want to ask you to imagine the way our current expungement laws work. Imagine a young person, maybe even someone who's related to you, was caught stealing something as simple as a candy bar from a convenience store. Now, do you think it's fair 10 years after that incident occurred for an employer to see the words theft conviction on a job application? And even something more serious than that, a nonviolent offense, is it fair 15 years or more, sometimes the way the waiting periods are calculated, 20 or more years later, for someone to be denied housing and employment that might otherwise be the key for them keeping their life on track and keeping them from going back to having to resort to criminal activity? And even more importantly, the expansion of the types of offenses that are eligible is crucially needed, because the way that the current statute works, it omits a vast number of very minor offenses. I have seen things on my client's record, like riding a bicycle on a sidewalk, or obscure sorts of licensing things like fishing violations that block otherwise eligible cases and leave someone with a permanent record. People have been denied access to participating in their child's field trips because they have these things on their record that happened 20 some years ago. I do want to address, I know that there will be some opposition related to the cost of hiring people to process expungements. I just want to say very frankly, when someone has something on their record, a misdemeanor from 25 years ago, can we really look that person in the face and say, you can't get a job, you can't attend your child's field trip because of this offense on your record, because simply the courts don't feel like paying for it to be expunged? I don't think that sounds like justice. And I don't think that our state should be one where people have to be judged permanently based on their worst moments and not who they could be.
Right.
So I greatly appreciate the opportunity to be here today. Thank you.
Thank you. I believe that Mr. Coleman is now with us. Harold Coleman, please.
Yes. Can you hear me?
Go ahead. Yes, for 2 minutes, please.
Yes. My name is Harold Coleman, and I'm in support of HB 1442. I'm I'm a convicted felon, and back in '97, I was convicted of felony theft. I served my time. I was sentenced to 13 years. I did 7.5 years on the 13 years. I was released in 2005. And once I was released, I stayed on parole until mandatory super release date of 2009. After that date, my sentence had expired. So the 15 years that I had to wait started then. And I've been currently employed with the state of Maryland since 2006. And I'm still in current employment with them, and I'm doing very well. But the problem is I cannot, get these felonies expunged. And I think that the waiting period is just way too long for people like myself and other people that's coming behind me to want to get back in the community and get jobs and move forward. And suggest a favorable. Hello?
Yeah, thank you very much. The chair has had to step away for a bit, so I apologize. We have Chris Dews next for 1 minute.
Can you hear me?
Yes. We can hear you.
2 minutes. Christopher Dews, are you 2 minutes whenever you're ready?
Apologies, but I just called. I'm sorry, my audio was a little loud.
Yeah, go ahead. You have 2 minutes when you're ready.
Fantastic. Thank you so much, Vice Chair Moon. My name is Christopher Dews. I'm the Senior Policy Advocate of the Job Opportunities Task Force, here today in stark support of House Bill 1442. I just want to go briefly through, what this bill does and what it doesn't, what it does and what it does not do. Of course, with us at JOTF, this is all about criminal record expungement. Having a criminal record is a massive barrier to employment, housing, education, occupational licensing, and even public assistance. 1.5 million Marylanders have something that will pop up on a criminal record. So if this is going to be a barrier to people getting ahead in life, even after they have returned from their sentence, we have to do something to reduce these waiting periods. So this bill specifically looks at reducing most misdemeanors down from 10 years to 3 years. It looks at second-degree assault, which is a very wide breadth of different types of offenses that come into second-degree assault, from throwing a cell phone to somebody, just bumping into a police officer. We're trying to bring that down from 15 years to 5, as well as common law battery. It looks at non-convictions, acquittals, dismissals, no pros, bringing those down from 3 years to immediately. Probations for judgments, from 3 years to eligible at the completion of probation. Those are the big ones, as well as certain non-violent felonies from 15 years to 5. But moreover, something I want to just highlight here is what the bill does not do. It does not, with the new language that we have introduced in the sponsor amendments, it does not affect DUI charges. It does not affect sexually related charges. And it also does not affect anything having to do with crimes of violence, hate crimes, animal cruelty, all the rest of the more heinous things. This is simply about reducing what is known as the street sentence. You have served your time. You have served parole or probation. You have finished drug treatment. You've done everything you're supposed to do, and now you're released back into society, but have to wait, as Chris Sweeney said, maybe 10 years to get that misdemeanor expunged. We think that line is a little too long. As my colleague Caleb Josso said, other states have already reduced that window tremendously, and Maryland ranks number 42 out of 50. 42 as for the longest waiting periods for misdemeanors specifically. So with all of that said, yeah, we want to reduce this. I just want to name one last thing. This bill has nothing to do with the unit rule, and also though the cost may be somewhat gradual, only because more people are going to be applying for expungement. We think that more people applying for expungement is a good thing because it's going to increase access to employment for millions of Maryland workers. I am down to answer any questions that anybody may have about the technical aspects of the bill. So with that, I urge a favorable report, and I'm open to any questions. Thank you for your time.
All right, next we have Elena McWilliams for 2 minutes.
Hello, my name's Elena McWilliams. I'm here in support of House Bill 1442 as a representative of Out for Justice. I'm the policy and research coordinator there. Out for Justice is an organization led by individuals who are both directly and indirectly impacted by the criminal justice system. We advocate for the reform of policies and practices that adversely affect successful reintegration into society. And I'm here just to highlight, I think we all share the same goals. Successful reintegration after people have been involved in the legal system, decreased recidivism, and reduced overall costs for everyone. But as a researcher, I want to share with you that studies show that negative attitudes towards people with criminal records are pervasive and subjective. They're influenced by people's political affiliations, their personal experiences of being a victim of crime, their history of contact with people with criminal records. And as a clear result, large-scale studies have demonstrated that people with criminal records receive fewer callbacks from employers, experience ongoing social rejection, and then encounter discrimination by individual landlords. And when this happens, people's impressions of themselves changes, and this leads to mental health challenges, fear of engaging in new opportunities, and more actual physical health impairments. And this increases their likelihood of recidivism. And all of this together creates more cost for our communities. It is a lose-lose situation when we do not let people restart, especially for crimes that are not crimes of violence. I mean, these are very simple charges to expunge and very simple ways for all of our community to benefit if you are to support House Bill 1442. Thank you.
Thank you. Now we'll take questions, and it looks like we have one from Delegate Davis.
Thank you, Mr. Chair. My question is for the bill sponsor. I want to thank you for this very important legislation, first and foremost. And I think my question is probably for people watching. We know that you come from a law enforcement background. Tell us and everybody watching why you think this bill is important.
Wow, I didn't know you knew that much about me, but back in the 1970s, I worked as a pretrial release investigator in Baltimore City, and then I worked as a court commissioner for a couple of years. And of course, then I went to law school, and I've been a criminal defense attorney for the past 30 years. And I come across folks who have had problems getting jobs, problems getting housing, problems getting into school, problems getting loans, problem even buying a car because of their past background that is exposed to everybody now that case search is available. So much so that about 6-7 years ago, we did pass a bill called the Shielding Act that at least kept your record off of case search. But still there's a great need to ensure that a mistake that a person made 5 or 10 years ago, whether it was a felony or a misdemeanor, doesn't hold them back forever. I mean, look, you serve your period of probation or you served your time and it's been 10 years. That person has changed. That person is now trying to probably raise a family, trying to get the kids in school, whatever it is. We're trying to give those folks the opportunity that most of us already have. And it's unfortunate that the people who write the fiscal notes aren't able to assess the social costs of folks not being able to get jobs, not being able to get health care, and perhaps doing alternative things that we don't want them to do. So this bill is so important to try to continue on in that vein.
Thank you.
Delegate Crutchfield.
Thank you, Mr. Vice Chair. And this is also for the bill sponsor. Delegate Anderson, I noticed in the bill, there's a waiting period after the person, I guess they're applying for the expungement. And that waiting period time is 3 years, I believe, before the actual charge is eliminated from their record. So what happens? Is this sort of like shielding for that period of time, or is it taken off the case search, or how does that work?
Okay, this bill does expungements in two different ways. Automatic expungements currently, like for null process, not guilty findings, dismissal, those can be expunged immediately without you having to do anything, but you have to wait 3 years, or you have to sign a waiver saying, I'm not going to sue whoever as a result of my arrest. I want to get my record expunged and I'm going to forgive them, or whatever the deal is. There's also expungements of felonies and misdemeanors in this bill. And there are waiting periods for several different categories. But during the period of time that you're talking about, where the person can wait, it doesn't, the information about the arrest is taken out of public view, but put in an area that is accessible to only, let's say, the court or the police if they need it for additional cases. So we've covered that as far as the concerns that the state attorney's office had raised to make sure that those records are available if needed.
Okay, thank you.
You're welcome.
All right, thank you very much. We have one person signed up in opposition.
Delegate Howell looks like she's got a question, Mr. Chairman.
Yes, go ahead, Delegate Howell.
Yes, this is for Delegate Anderson. Thank you for this bill. One thing that I wanted to know was it says that this bill excludes some felonies. Could you tell me what those felonies might be? Is it for, and specifically, I'm looking for people who were convicted of felonies of selling crack cocaine. And I know that it was a felony, but there are a lot of people locked up for that and in trouble for that. So I just wanted to know, does it exclude that?
Okay. In the Maryland Code, in the criminal law article 14-401, 14-101, is a list of the violent crimes that exist, what we call violent crimes in the state of Maryland. This bill excludes all of those violent crimes. They include murder, rape, armed robbery, carjacking, and certain drug felonies, the one you just talked about. It also, this bill will also exclude felonies that involved anything that would put you on the sexual predator list. So, any of the various degrees of sex crimes that would put you on a list, you cannot ever get that expunged, at least as far as this bill is concerned. You can't get child pornography expunged. If you hurt someone while driving drunk, you cannot get that expunged. So there's a list of all those offenses in the bill that cannot be expunged through this bill. Some felonies can, but not the more serious ones that you just talked about. And we're saying that basically more misdemeanors can be expunged. And again, except for the ones that I just mentioned.
Wow. I wonder, will selling crack cocaine ever be expunged? I'm wondering about that.
Okay, well, there's actually no law stating, there's a law, the law says possession with intent to distribute cocaine or the distribution of cocaine, but there's nothing in the law that distinguishes regular cocaine from crack. The word crack cocaine is not in Maryland law. It's a distinction made by police officers once they make an arrest to try to make it look terrible. This person, it's crack cocaine because it was in chunk form. Mm-hmm. But the analysis always comes back cocaine based and in a certain percentage or certain purity.
Thank you.
All right, now it looks like that's the end of the questions. So we will now go on to the opposition. We have John Cox signed up to testify in opposition. Do we have John Cox in the waiting room?
I'm here, sir.
There you are. Great. Cox, you have 2 minutes when you're ready.
Thank you, Vice Chair Moon. Members of the Judiciary Committee, I'm John Cox. I'm Deputy State's Attorney for Baltimore County and also speaking on behalf of the Maryland State's Attorneys Association in opposition to House Bill 1442. Delegate Anderson's right. We talked this morning. It's difficult for me to figure out how to respond because my written testimony was addressing the bill as it was submitted. I don't know if it's actually been amended to this point. So I may not get into great details about as it's currently written. I'd ask you to look to my written testimony to see all the problems. For example, right now, under this bill, you could expunge a PBJ the day after the person got it, even if they're supposed to be on probation for 3 years, it goes away and it has to be expunged the way it's written right now. Stets would have to be expunged after a year. There are a number of difficulties with the way that it's written. A lot of my concerns, but not all, are eliminated by what was sent to me this morning. I would love an opportunity to have a hearing on us addressing that actual bill. I honestly have not had enough time to digest it, to go through any concerns that I continue to have. I do know in looking at it that I do have some still concerns. The primary being the fact that it would open up to almost all misdemeanors and almost all felonies. If you look at the list I provided in my written testimony of both misdemeanors and felonies that would now be able to be expunged, it's quite concerning that somebody, child pornography, actually, I still don't even think has changed, such that you could expunge that after 3 years, a guilty finding. There are a number of other particular examples. I really think in fairness, what we ought to be doing, if this is going to be such a major reformation or change in amendments to this bill, that we have another hearing and actually address those particular pieces, so we can address the concerns that may be there. I mean, right now, just as an example, the expungements can happen from 3 years after a conviction. So somebody could get 3 years in jail, completely misbehave, never get a day of credit, and the day they step out, they're entitled to expungement. That clearly is not what the legislature intended when the legislature put in all of the pieces that address these particular issues in 2016 with the Justice Reinvestment Act, and allowed expungement of a number of convictions. I'd ask for an unfavorable report. I'd ask for an opportunity to address the amendments when we're all able to digest them. Thank you.
Thank you. Delegate Anderson.
Yes, and let me just say that, number one, I've known Mr. Cox for many, many years, and we can sit down, and in fact, I suspect that the vice chair, who's the chairman of the Criminal Justice Subcommittee, is already probably thinking about putting this together in terms of us sitting down and going over amendment by amendment or crime by crime to see which ones should and should not be available for expungement. As I mentioned, child pornography crimes, all sex crimes, all those things we want to take out. Any crime which is a crime of violence, we want to take out. Domestic violence crimes, we want to take out. And we will sit down. And I apologize for not having gotten this bill in earlier, but I know that you had these same concerns last week in the Senate. Those concerns were noted, and the things that you had concerns about are the things that we think we can agree on taking out. So I will be in touch, and our subcommittee probably will be the ones where we have this additional hearing.
I appreciate that, Delegate, and I'm happy to help with anything.
We're going to count on you.
All right. That looks like the end of the questions on House Bill 1442. Do we have the Chair of Ways and Means here? If so, that'll end the hearing on that one, and we're going to move on to House Bill 1396. Let's see. Yep, there she is. Great. All right. So we have Delegate Atterbury, and there will be 5 witnesses on the favorable panel: Arndt, Elaine, Alexandra, Mattia Novak, Aaron Davis, Sam Levy, Tanya Shart.
Mr. Vice Chair, apologies to interrupt, but we just have a sponsor panel set for Ms. Aaron Davis and Mr. Sam Levy.
Got it. Okay, wonderful. Let's do that then. The chair has 3 minutes when you're ready.
Thank you, Mr. Chair and committee members. Good to see you again. This is the last time I will be seeing you in your committee this session. This is a new bill. And first, I just want to thank the committee and specifically Dylan for working with me. And if I have to take my face off the screen at some point during this, I'm trying to negotiate this gas holiday thing you may have heard about. This bill is about holding the gun industry accountable. For nearly 2 decades, a federal law known as the Protection of Lawful Commerce in Arms, otherwise known as PLACA, has shielded bad actors in the gun industry from lawsuits that would hold them accountable for their role in fueling the epidemic of gun violence. This broad protection has prevented individuals and communities injured by gun violence from filing civil suits against these bad actors, giving the gun industry little incentive to change their dangerous and irresponsible practices. This year, we have an opportunity to enact legislation that would allow these types of civil suits to move forward despite PLACA. This would create a path to accountability for gun manufacturers, wholesalers, and retailers, which is essential to stemming the flow of illegal guns here in Maryland, ensuring basic product safety and marketing standards are met, and finally holding bad actors within the gun industry accountable for the harm that they've helped cause. This bill would create a firearm-specific state public nuisance law for Maryland and make clear that gun companies that engage in illegal or unreasonable conduct that harms Marylanders are creating a public nuisance in the state and can be sued for it. The bill also requires all gun companies who do business in Maryland to put in place reasonable safeguards to prevent their guns from ending up in the hands of people who shouldn't have them. PLACA allows the firearm industry to continue to be large, lucrative, and with no accountability. And this legislation would change that here in the state of Maryland. Thank you for your time and attention. And Mr. Chair, I would like to turn it over to my panel. First, Mr. Levy.
All right, Mr. Levy, you have 2 minutes when you're ready.
All right, thank you, Mr. Vice Chair. Thank you, Madam Chair. My name is Sam Levy. I'm Senior Counsel at Everytown for Gun Safety. It's good to see you all again. And I'm here to urge a favorable report on this important piece of legislation, and I thank the Chairwoman for bringing it before you. As she said, since 2005, the gun industry has enjoyed an unprecedented and unique degree of immunity from civil liability for lawsuits brought by the people whose lives are cut short or who are injured by the misuse of firearms in this country. And it has stymied efforts to keep the industry accountable ever since that time. It's a unique protection afforded only to the firearm industry, and it literally makes it impossible to bring a suit by victims and their families. And what this law would do is use an exception in the federal law known as PLACA, the Protection of Lawful Commerce in Arms Act, to ensure there is a path forward so that these lawsuits can proceed. And it would do that, as the chair said, by simply putting standards in place in Maryland that create a state law that puts the industry on notice of how it must behave and the conduct in which it must not engage, and that results in harm to communities across Maryland. Simply put, it puts them on notice that if they engage in conduct that is unreasonable, conduct that is illegal, conduct that is reckless, and that reckless conduct contributes to or results in injury and harm in the state, they're causing a nuisance. It also puts them on notice that they have to put reasonable measures in place to prevent very basic things like the theft of firearms from their stores, right? Sales to straw purchasers, things that bad actors in the gun industry, from manufacturers and wholesalers on down to dealers, do far too frequently now. And that makes it possible for guns to be continually fed into the illegal market and to turn up on the streets of cities across Maryland and across the country and take far too many innocent lives. So what this is really a chance for the industry to finally be held account in the way that so many other industries are for bad actions, for their misconduct, and to finally give them some incentive to make their products safer, to put procedures in place to make sure that they are doing all that they can to prevent the kind of harms that they know are resulting from the sales of their products in Maryland and across the country. Thank you all for the time, and I urge a favorable report.
All right, next we're going to hear from Aaron Davis for 2 minutes.
Hi, Vice Chairman and distinguished members of the Maryland House Judiciary Committee. My name is Aaron Davis, and I'm the Senior Counsel with the Brady Legal Team, where we litigate cases on behalf of victims of gun violence all over the country and here in Maryland. I'm also a Maryland resident. Thank you for the opportunity for me to speak today in support of House Bill 1396. In 2005, a law referred to as PLACA was passed by Congress. While PLACA doesn't provide complete immunity from all civil lawsuits, some courts have interpreted it to effectively bar the courthouse door from victims and survivors of gun violence who have been injured as a result of the irresponsible, negligent, or dangerous gun industry conduct that would otherwise be actionable under basic civil justice principles. I know this all too well. Unfortunately, since the passage of PLACA, these businesses have been afforded special protections not found in other industries, which often result in dismissed cases that drag on for years pending appeal based on PLACA, and victims of gun violence and attorneys' reluctance to bring cases, which is resulting in a chilling effect in denying these victims access to justice. This is true in Maryland and across the nation. I currently represent a family of a victim of gun violence in Maryland. Defendants have filed a motion to dismiss based primarily upon PLACA, and it is unknown whether this family will ever have the opportunity to see the inside of a courtroom. House Bill 1396 will ensure that those tragically impacted by negligent, irresponsible, or dangerous business practices can pursue claims. This bill will also incentivize gun industry's members to engage in reasonable and safe business practices, which will prevent the gun violence before it happens and curb the flow of crime guns into communities disproportionately affected by traffic firearms like Baltimore. No industry should be above the law. When industry members negligently or recklessly sell, market, or distribute firearms, they should be held accountable like every other industry. This bill would ensure that's possible. Thank you to Delegate Attenberry for introducing this important piece of legislation.
All right, we have questions from Delegate Shetty and then Lopez.
Thank you, Mr. Vice Chair. Thank you, Chair Atterberry, for bringing this bill. It's always great to have you in our committee. So my question is for Mr. Levy. If you wouldn't mind, please, I know our testimony time is so short, but since this is a new bill, I would love to hear a little bit more about how the bill would actually work. And I know you gave a few examples of the type of misconduct potentially that could be reached by it, but if you have any others, I would really appreciate it.
Sure. Thank you for the question, Delegate. So mechanically speaking, so PLACA, the federal law, bars basically wholesale suits brought by victims of gun violence that result from illegal use of firearms against members of the gun industry. And that term includes manufacturers, wholesalers, and retailers. And what that means basically from the moment the law was passed in 2005, it was actually retroactive. So it wiped off the books a whole slew of lawsuits that were pending against the industry at the time, and has been continuing to block those lawsuits going forward. But the law is not absolute. And one of the things that it exempts is conduct by gun industry members that is knowingly in violation of some state or federal law. So if, for example, a gun dealer sells a gun without a background check in violation of federal law to a felon, and that felon kills someone, they're not shielded by PLACA because that conduct is in violation of an existing statute. They call it the predicate exception. So if there is an existing state or federal law that applies to the business of selling or marketing or manufacturing guns, and you violate that law, you're not entitled to the protections of the federal law. So what this bill endeavors to do is to create such a statute for Maryland. So it would be a law that's applicable, as you can see on its face, to the conducting of business of manufacturing, wholesaling, retailing firearms in Maryland, and put people who are in that industry on notice that if you violate the terms of this law, which, as I said, basically sets up a fairly standard, common law nuisance theory that says, look, if you engage in conduct that contributes to or creates a nuisance and causes harm in our state, we have recourse not only to investigate and look into it, but to bring suit. And because this law exists, the people who engage in that misconduct would no longer be able to avail themselves of PLACA. For example, think of examples in other industries like opioids, right? Pharmaceuticals, right? Manufacturers and wholesalers whose practices contribute to the opioid crisis have since been held accountable in courts through lawsuits that just don't exist against the gun industry because PLACA has blocked those efforts for nearly 2 decades. And so that's the mechanics. And in terms of the kind of conduct we're talking about, it can range from the dealers themselves, right? We know a very small fraction of dealers who engage in misconduct are responsible for the vast majority of traffic guns that end up in places like Baltimore and cities and towns across America. The vast majority of the industry conducts their business responsibly and cares for their inventory, but there are a great many who do not. For example, a dealer could be showing a gun to a customer who's clearly intoxicated or inebriated, is mumbling about their wife. They could put that gun down on the counter and go to answer the phone, and that person could pick it up and walk out of the gun store and use it to kill their wife. That conduct's not illegal on its face under federal or state law, so they're not responsible for that under PLACA. They can say, well, reckless, sure, negligent, sure, but sorry, like that's not illegal. You can't sue me. this would help get at that, right? And it could also be used really importantly for going further up the chain, right, to manufacturers and wholesalers for marketing practices, record keeping. If you're a wholesaler or a manufacturer who provides guns to a dealer, so again, every time a crime gun is traced, ATF or law enforcement are calling the manufacturer to tell them there was a crime gun recovered, right? And they're going to know that they sold that gun to a given gun store, and that one gun store could be yielding hundreds of crime guns a year. They have a choice to make, right? They could stop selling guns to that dealer they know is reckless and irresponsible and is fueling the illegal market, or they can choose not to. That choice is not criminal. So if they put their hands in their pockets and say, sorry, it's not my problem, there's nothing we can do about it in the face of PLACA. But again, with a law like this in place, you could, by saying, look, that conduct is clearly unreasonable, and it clearly is creating harm here in the state, and you can now be held responsible for it.
All right, next we'll have Delegate Lopez and then Delegate Tolles.
Thank you, Mr. Chair. And Madam Chair, it's always good to see you back in our committee. Thank you, Mr. Levy, for explaining kind of the nuts and bolts of this, because it is a bit abstract. And you mentioned in your last answer that pharmaceutical companies are now being held accountable for their participation in the opioid crisis. And I'm wondering, thinking it from the other side, are there analogous protections for other industries?
No, I mean, simply put, there's, tobacco, the automotive industry, pharmaceuticals, products that are either inherently dangerous or could be dangerous as used, are held to different standards in the gun industry. They're held to common sense standards that say, look, if you create a product and fail to innovate it, if you don't put seatbelts in your cars, if you sell, hundreds of millions of pills of opioids into the market in ways that are clearly fueling an ongoing epidemic, you're going to be held responsible. And in 2005, Congress basically gave a gift to the gun industry that is completely unique in this country. Nobody else gets this sort of blanket immunity. Nobody else gets this protection. The NRA called it the most important piece of pro-gun legislation in 20 years when it was signed into law in 2005, and they were right. I mean, it's basically wrapped them in an immunity blanket that no other industry is afforded, and it's allowed them to operate with impunity for years and years and years. I mean, with very few exceptions, that's been the case since the law was signed in 2005.
Thank you.
All right, Delegate Tolles.
Good afternoon. Thank you, Mr. Vice Chair. Thank you, Madam Chair Atterbury, for bringing this bill. I think it's a great piece of legislation. So I just have a question either for the chair or Mr. Levy or Ms. Davis. Ms. Davis actually mentioned, or Mr. Levy may have mentioned, that someone could, be able to purchase a gun or go for a gun, have mental illness, is placed on the counter and walk away and commit a crime and not be held accountable for, and the victim won't be able to sue. Can you give any recent examples of any lawsuits that have been able to proceed despite PLACA, thanks to the violation of a state law?
Erin, do you want to take that one?
Yeah, I'm happy to. So the answer is that there absolutely are cases that are able to proceed. I litigate them all the time. And there's certainly cases that have not been able to proceed. I think the idea with the predicate exception and why this bill is so important is that PLACA is really limited to laws that are on the books for state and federal violations of law. And PLACA contemplated that. So if you look at the language of PLACA, it actually allows states to pass bills, and it allows, obviously the federal government to pass bills as well that absolutely apply to this particular issue. So, for example, if you have a bill, if you were broadening this, it would cover reasonable care, which is what's commonly covered in common law tort law. And how this is unique is that you don't necessarily codify every single reasonable care tort violation. A lot of that is developed in common law, and gun dealers, as do every other industry, knows what they need to do. You can't sell, for example, you can't sell a tuna fish sandwich that's spoiled. If you do, you can be sued for it. The gun industry can't be sued for that because that's not a codified law. So what this bill really effectively does is exactly what PLACA intended it to do as part of the exception, where it creates an opportunity for states to pass important legislation that work with PLACA to allow victims of gun violence not to be treated as second-class citizens and be treated like other victims who are injured.
And if I may just briefly, Delegate Tolles, I think you may have read, the suit that just settled in Connecticut after the Sandy Hook tragedy, right? That was a lawsuit that's years and years old. That was one of the very few that survived a PLACA challenge, and it survived because Connecticut has a consumer protection law that they could rely on as a predicate statute. And they got to say, after many years of hard effort, that like the practices that Bushmaster was engaged in their marketing that glorified this sort of interpersonal violence led directly to that tragedy. And ultimately that settlement is an example of a suit that survived PLACA and ultimately led to, as you saw, not just the bankruptcy of Bushmaster, but a tremendous settlement for victims of an unspeakable tragedy.
Thank you for that. Tort law was actually one of my favorite classes in law school because I think everyone, regardless of your industry, regardless of what you do, should have a reasonable amount of care in protecting, our fellow citizens. So thank you for that. Thank you, Mr. Vice Chair.
All right, we have 3 more witnesses. Arndt Elaine, Alexandra Mattia Novak, and Tanya Sharp. Alexandra, you have, if you can hear me, you've got 2 minutes when you're ready. Alexandra, you have 2 minutes when you're ready. You need to unmute yourself. There you go.
Good afternoon, Chairman Clippinger, Vice Chair Moon, and members of the committee. My name is Alexandra Mattia Novak. I live in Reuben, Maryland in District 33 and delegates Bagnall, Munoz, and Saabs District. I am a volunteer with the Anne Arundel County local group of the Maryland chapter of Moms Demand Action. I'm also a survivor of gun violence and a gun owner, so I have the unique burden of seeing this issue from both sides as both a supporter of the Second Amendment and someone who has personal experience with how our weak gun laws continue to fail our communities and make our streets less safe. As gun owners, we should all want higher standards of ownership and sales practices that put safety first to protect our communities. I am here in support of HB 1396, and I ask for a favorable report. This legislation will rely on an exception to the federal PLCA law to allow lawsuits to go forward against gun manufacturers and dealers whose reckless and illegal conduct puts our communities in danger. PLCA protects gun makers who continue to sell to dealers who fuel the criminal market, have poor safety practices or training, or are not willing to use basic security measures. This bill would counteract that by creating an affirmative requirement for gun manufacturers and dealers to put these types of safeguards in place. A common source of crime guns are those stolen from gun dealers, and PLCA shields the gun dealers who've taken no steps to secure their premises when their guns are stolen and then used in crime. As a resident of Anne Arundel County, I'm all too familiar with the dangers that stolen guns have in our community. In 2021 alone, 152 guns were lost or stolen from licensed gun dealers in Maryland. It's not right that this industry has been able to profit so much while doing nothing to remedy their reckless sales practices, while communities continue to suffer. This bill is a small step, but important towards holding this industry accountable. Thank you for your time.
Thank you very much. Next, we will hear from Elaine Arndt for 2 minutes.
Thank you, Mr. Vice Chair. My name is Elaine Arndt.
I live in the city of Baltimore and I'm a proud resident of District 46, so please give my regards to Chair Clippinger when you see him. I'm also a volunteer with the Baltimore City Local Group of Maryland Moms Demand Action, and I'm asking for a favorable report on HB 1396. On average, 743 Marylanders die by gun violence in a single year. An additional 1,700 are injured by gunfire. These Maryland survivors of gun violence deserve the opportunity to hold manufacturers and sellers accountable for reckless conduct that leads to any deaths and injuries. This bill would create a pathway for those who are injured to hold the gun industry members accountable for misconduct, despite the federal law that's shielding them from liability. This bill also permits investigation by the Attorney General in cases where Marylanders have suffered damage from their reckless or illegal conduct. When firearms industry members are accountable, they have incentive to design their products more safely and to stop selling to dealers who support the criminal market, or have poor safety procedures or training, or are not willing to use basic safety measures to prevent theft and gun trafficking. Just last year, 23 firearms were stolen from a Harford County pawn shop where they were taken from glass cases. There are ways to prevent firearm theft, including locks and bars. Marylanders should be able to hold firearm industry members accountable when they have suffered injuries as a result of their misconduct. I ask for a favorable report and thank you for your time.
All right, are there any questions for this panel? Seeing none, we can now move to the opposition. We have 4 folks signed up: Trevor Santos, John Jocelyn, Mark Schneider, and Frank Boston. Let's give them a minute to trickle in. I see them trickling in. Trevor Santos is signed up first. Trevor, you can unmute yourself and you've got 2 minutes when you're ready.
Good afternoon, Vice Chair, members of the committee. My name is Trevor Santos. I'm here today on behalf of the National Shooting Sports Foundation to speak in opposition to House Bill 1396. NSSF is the trade association for America's firearms, ammunition, and recreational shooting sports industry. House Bill 1396 is nothing more than an attempt to bankrupt America's firearm industry. These are the businesses that supply law-abiding Americans, law enforcement agencies, and the U.S. military with firearms, ammunition, and components. Specifically, House Bill 1396 seeks to circumvent the Federal Protection of Lawful Commerce in Arms Act, which passed in 2005 by a majority of Democrats and Republicans in both houses of Congress. The PLCAA does not grant blanket immunity, as some have suggested, including President Biden. Such a suggestion is a lie. Manufacturers and firearms retailers can and are held responsible for harm caused by defective products, breach of contract, criminal misconduct, or other actions of which they are directly responsible. That's the same liability as any other product manufacturer or seller. The PLCAA was passed by Congress to correct the abuse of the judicial system that began in 1998 when cities and counties in one state started filing frivolous lawsuits that sought to blame firearm manufacturers, distributors, and retailers for the criminal misuse of firearms, holding members of the firearm industry responsible for a criminal misuse of its lawfully manufactured and sold products would be the equivalent to declaring drunk driving a public nuisance and then imposing liability on Ford for lawfully designing, making, and selling a car that was later used by a drunk driver who causes an accident. The National Shooting Sports Foundation opposes this ill-advised and ill-considered bill that will not improve public safety, but will result in litigation and drive business out of Maryland. We would respectfully request an unfavorable report for House Bill 1396. Thank you.
Okay, next we'll have John Jocelyn for 2 minutes.
Good afternoon, Mr. Chairman. John Jocelyn speaking for 2A Maryland. House Bill 1396 is nothing if not inconsistent with federal law. The Lawful Commerce Act The operative term is lawful commerce. This industry is already heavily regulated by both state and federal laws. 5-701 would impose responsibilities and mandate actions that the industry does not have the authority to control, but these are already addressed by both state and federal law. It would prohibit false advertising. False advertising is subject to interpretation as to what is false. I'm sure you all understand that campaign promises could also be listed as being false advertising if they're not fulfilled. What is not really obvious in this bill is that it would also include the distribution chain. DHL, United Parcel, FedEx, all of these carriers would be impacted. Section 5-704 authorizes actions that sound very much like a play from Vladimir Putin's legislative playbook. It would authorize the Attorney General of Maryland to engage in a witch hunt based upon no specific level of proof. Merely suspicion would be sufficient. Overall, this bill is anathema to the Constitution and to due process. And for these reasons, we ask for an unfavorable report. And we would mention that its cross-filed version has already been canceled in the Senate. We ask that this House do the same. Thank you.
All right, next we'll hear from Mark Schneider for 2 minutes.
My name is Mark Schneider. I am the manager of Atlantic Guns, my family's legacy designated business in Montgomery County. We are proud to have served the community for over 70 years. I oppose HB 1396.
That's why I moved.
To our ability to stay in business. There are many problems with this bill.
Mark, you need to unmute yourself.
Can you hear me now?
Yep.
All right. I'll start over. My name is Mark Schneider. I'm the manager of Atlantic Guns, my family's legacy designated business in Montgomery County. We are proud to have served the community for over 70 years. I oppose HB 1396 as it threatens our ability to stay in business. There are many problems with this bill. Data does not support the claim that Maryland licensed firearms dealers are the source of reckless, illegal actions by criminals. We are a highly regulated industry abiding by both federal and state statutes governing the sale of our products. No licensed dealer knowingly sells to the criminal market, as federal and state law already prohibits this with severe civil and criminal penalties. Vague terms such as unreasonable sale, reasonable safety measures, deceptive act or practice, reasonable controls or procedures, and false advertising are either not defined or not clearly explained, and thus unacceptable terms. This bill would open every licensed dealer to frivolous punitive litigation, and if enacted into law, would make it impossible to obtain insurance. Without insurance, no dealer could stay in business. Dealers should not be held liable for the legal and lawful sale of firearms. Those who commit illegal acts with firearms should, and we support stricter penalties for those who illegally use firearms. I request an unfavorable report.
All right, and next we've got Frank Boston for 2 minutes.
Yeah, good afternoon, Mr. Chair and members of the committee. I'm Frank Boston III, and I had to find a corner in the Senate building, so hopefully you can hear me. My clients, the Maryland Licensed Firearms Dealers Associations and the NRA, and respectfully, we oppose this bill. The bill places liability on gun shops for the criminal acts of a third party. On page 4, line 12, it states that the proximate cause of, quote, reasonable foreseeable effect. I proffer to you that these acts are unforeseen. The criminal acts of a third party, if we see anything going on or know anything going on, of course, it's in our best interest to let the police and the proper authorities know. Also, how can we be held liable for something that is unforeseen? This leads to a court case, and because this is the issue of foreseeability is a jury question. Secondly, the bill also makes us establish procedures for controls. We are already heavily regulated, have many controls and procedures in place. There's no reason for another layer when we are already regulated by the state and the feds and everyone else. So for these reasons, we respectfully oppose this bill. Thank you.
All right, we have questions from Delegate Shoemaker and then McComas.
Thank you, Mr. Chair. This is for Mr. Jocelyn. So, sir, I mean, you testified that you believe this bill is inconsistent with, I guess, what's the acronym? PLACA, whatever it is, that the federal law. Can you refer specifically as to how it's inconsistent with federal law? And do you have an opinion as to whether this proposed legislation is preempted by that PLACA statute, the federal law?
Okay, to begin with, I believe that PLACA was put in place to protect the arms industry from lawsuits for situations beyond their control. If they deviate from the existing state or federal law, they may no longer have that shield. The whole intent was to stop the frivolous lawsuits that have been aimed at the arms industry for the actions of others. For example, it would be the same as if we held the Maryland General Assembly responsible as a body for the actions of delegates who have been convicted of crimes over the years. We have a long history of that in Maryland, but we don't hold the General Assembly responsible. We don't hold the members responsible. We hold the individual who committed the offense responsible. And this bill is basically a wide spectrum attack on the arms industry simply because that's where the money is. And I'm sorry, I forgot the rest of your question, sir.
That's okay. That's good. I appreciate it. Thank you.
Delegate McComas.
Yes, I would just like to ask anyone of the opposition. It seems to me that if you've got a business and you're in this business of the guns, you're not, and this bill passes, I don't know who would want to insure your business. Would anybody like to comment on that?
I think that's the intent of the bill, Delegate.
So really, this bill should just be say, we don't want any gun manufacturers in Maryland, go somewhere else.
Essentially, that's true.
The insurance company, the insurance company that we've been using for decades would not insure us under this bill.
Yeah, I mean, because I was kind of thinking, I mean, because I sort of sitting here looking at it and I'm going, so what kind of, okay, you do the background check, you do all this stuff, and then you're still going to get accused of selling guns to somebody illegally or something, because everything you did was legal. I mean, I just think that I think the bill is very vague as to what maybe I'll leave this for Mr. Boston. What kind of crime, I guess, what scenario would you see that somebody could get snarled up in this bill as it's written?
Well, for one, you can sell a gun to a legal person, right? You could do all of the checks and this, that, and the other. Somehow, some way, by theft, by whatever, the gun ends up in the hands of a criminal, right? And then they trace the liability back through the purchase to the actual gun shop, all the way up the line. And everybody in that line, as you know, I am a lawyer. I'm a trial lawyer. You sue everybody. So everyone who's going to get sued, who's in that whole chain of custody. Moreover, it can be a legal person defending their home or defending what they think is right, defending themselves against a robbery. But somehow or another, in the wrong jurisdiction, and I'm not going to say which ones, you get charged because you were defending your own personal property. But so they have to deal with that. But then everyone involved into the legal sale to this, citizen who was trying to defend themselves still gets sued or could get sued. So the chain of custody is far reaching and can imply not only the manufacturers, but the gun shops and any other licensed firearms dealers.
I guess I kind of compare it to a lot of the bills that we've had regarding the architectural industry, you know, when they want to basically stop all the discovery because they weren't the persons at fault. And they can kind of prove pretty soon, but I can see if this bill passes 10 years from now, we're going to be putting in bills that limit the discovery for the gun manufacturers, if we have any at that point, because of the horrible costs of discovery. I mean, is that a fair assessment if it passes?
I believe that there is a financial decision that often has to be made is what is the lesser of the evils, paying them off to get rid of them, or fighting the battle and end up losing the whole war because you're now bankrupt.
Right. And foreseeability is totally subjective. What one jury can see is foreseeable in, you know, one county, the very next neighboring county or county far away, a jury could find something different. So it's very subjective.
Thank you very much, gentlemen.
Yep.
All right, Delegate Bartlett.
Thank you, Mr. Chair. Quick question, I guess for Mr. Boston. What does in the bill, not even in the bill, just in general in law, what does knowingly or recklessly mean? And what is the standard for that?
It depends upon whether you're talking criminal or civil.
Well, as it pertains to House Bill, as it pertains to House Bill 1396, because that's the only thing I can reference right now.
Well, that's a good question. That's the question I have, because I think the bill's vague on that. So knowingly and recklessly, it could mean a lot of things. You know, I would imagine as a practical matter, knowingly and recklessly means you knew that this person had a criminal background record. You knew this person was a bad actor, and you sold, and in the case of my clients, you sold a gun to them. And you knew that they were going to go out and do something bad. And I say to you, why would we ever do that when we would lose our license to own a gun shop, license to sell licensed firearms forever if we knowingly and recklessly did that? We're in the same position. And I think the goal is the same as the sponsor and I guess members of the committee. No one wants guns in the hands of bad people. We don't want that. It's not a good look for us. It's not a good look for our businesses. It's not a good look for the NRA. It's not a good look for anyone. So knowingly and recklessly means you knew or should have known. Maybe we could throw that standard in there.
Or that you could even have like constructive knowledge, right? Under the should have known.
Well, that's, you know, the constructive knowledge again is a slippery slope. It becomes a jury question because you have to prove facts. As you know, Counselor, you have to prove the facts of whether a person knew or should not or should have known. And that again becomes a question of fact, not necessarily a question of law, which is expensive, causes lots of litigation, and, you know, to the previous opponents, causes us not to be insured at all.
Okay, so let me just go to page 4 for 1 second of the bill, section B, where it reads that a firearm industry member that manufactures, markets, imports, or offers for wholesale or retail qualified product, et cetera, shall establish and use reasonable controls and procedures to prevent the product from being used, possessed, marketed, or sold unlawfully in the state. That doesn't sound unreasonable to me. That sounds like something that, you know, it goes in line with what a reasonable firearm industry member should do.
Yes, and in my testimony, I referred to that exact section. Thank you for the question. We already do it. And you know, of course, Mark, or who's actually a gun shop owner, can speak to this probably better. But we are already under, using the exact same words, reasonable controls and procedures from the federal government, the ATF, the state police, the state, obviously the legislature. They are already plenty of reasonable control. I would argue there are plenty of reasonable controls and procedures in place to prevent this exact act, to prevent a qualified product from being possessed, used, marketed, or sold unlawfully in the state.
Right. And so to me,
There's plenty of laws on it.
Mr. Chair, this is my last question. But to me, it would seem that because that is there, there are plenty of parameters that not only the firearm industry, but also the jury or the trier of fact can hang their hat upon. I mean, there's like a list of things to do.
Isn't that so?
I'm sorry.
Isn't that so?
I wasn't finished. Yeah, but there isn't, because I was going to say, because like if you look at the proximate cause, I mean, the proximate cause is outlined, the intent to cause harm, all of that is there. Isn't that so? Thank you, Mr. Chair.
Yes, I mean, I would say, I mean, we already had these procedures and everything in place, but if you stay on that exact same page, and I'm standing up, and you go down to, lines 9 through 13, when it starts talking about the conduct of the firearm industry member under section 5702, the subtitle, should constitute a proximate cause of the public nuisance if the endangerment of the health and safety of the public was a reasonably foreseeable effect of the conduct notwithstanding intervening actions. Foreseeability, again, is a jury question. How can we be held accountable to foreseeability of what can happen, 6 months from now, 6 years from now, to a gun that we legally sold to a qualified purchaser? And if it ends up in the hands of the wrong person by way of theft, by way of anything, under this bill, we can be held accountable, or at the very minimum, still have to hire lawyers, possibly lose our insurance if we get it, to have to defend on a case that it was unforeseen or unforeseeable for us to be able to ascertain.
And we could go at this all day, but I'm going to stop now. Thank you very much.
Yes.
Delegate Cox.
Thank you, Mr. Vice Chair, and thank you, panelists. Mr. Boston, Mr. Jocelyn, I think you're aware that Mr. Mark Pennick had attempted to sign up and was not able to do so, and has asked for his testimony to be included. And so, Mr. Vice Chair, without objection, I'd like to ask that his testimony be included. And I have a question about that testimony for Mr. Jocelyn.
Well, why don't you go ahead and ask your question? We can include the testimony.
Okay, thank you. So, Mr. Jocelyn, I'm not sure if you had a chance to look at Mr. Pennick's document that he submitted, but one of the points that Mr. Boston was just making was highlighted that I thought was relevant. It pointed out that the unforeseeability in this bill indicates terms, quote, health and safety, which are undefined, which then leaves potentially limitless liability. Do you agree with that analysis?
Yes, I do, and I believe that was intentional.
So you think that the bill drafter is wanting to kind of take away, even though it claims to be knowingly and reckless, that it's actually more almost a strict liability with the undefined terms?
I think this is something you would probably every town people would be in a better position to know the intent.
But from your viewpoint, it certainly could do that if the expansive and vague view is actually applied. Is that what your testimony is today as well?
This has been their standard operating procedure, yes.
Okay. Thank you for your testimony, gentlemen, and thank you, Mr. Vice Chair, for allowing that Mr. Pennick's testimony in. Appreciate that.
Thank you.
Sure thing. I'm told by the end of the week, maybe, so not instantly. All right. That looks like the end of the testimony on that bill, House Bill 1396. And so that's the end of the hearings today. We're going to have a criminal law meeting at 3:15. And my goal is going to be to wrap that meeting pretty quickly if possible, because I do believe we're attempting to vote at 4 or so. So I'll see the criminal law folks in